I'm Gwyneth John, one of the family partners at Stephensons, and Jackie Price is with me today to talk about interveners. Jackie and I do the majority of our work in cases where harm is generally accepted to a greater or lesser extent by those involved, and the main question is what should happen to the child. The harm to the child isn't always the most difficult issue. It is dealing with the problems that the parents or others have which resulted in the child being hurt, and how that child should be protected in future. The family team at Stephensons have very experienced solicitors, many of whom are on the children panel. We have experience of representing many different people in matters where there are allegations of significant harm to a child, resulting in the court being asked to use its protective orders to ensure that the child is not harmed again. This may or may not result in the child being removed from the family home.
For removal from home to be considered by the police or the courts, the child must have suffered significant harm. That is harm that can take place accidentally, deliberately, or negligently. It can cause physical harm, emotional harm, sexual harm, and many other types of harm, but all things that you wouldn't want a child to experience and that you would guard against. When faced with an injured child, the court have to look to identify how the injury was caused, whether it was accidental or inflicted, and if it was inflicted, look to identify the perpetrator and the mechanism by which they have sustained the injuries. This can be a lengthy process and can start when the child is presented to the hospital and concerns are raised regarding unexplained injury or concerns regarding the reported mechanism of the injury. We have represented parents, children, and interveners. The focus of today's discussion is how it affects those seemingly on the sidelines, and they are the interveners.
These are all the people who might have been responsible. Firstly, those who choose to request to be involved in proceedings because someone has accused them of doing something to the child, or more often people who have been identified by the local authority or police as potentially responsible for doing something harmful to the child. The parents and the identified interveners are often referred to as the pool of potential perpetrators. If the judge thought a person who was not a parent of the child who had been injured or harmed needed to be involved in the proceedings to get to the truth of what has happened, the person may be granted intervener status by the judge so that they could be heard by the court. They would be involved in and part of the process of care proceedings, not a party to the proceedings in that they would only be involved in the aspects relating to trying to work out how and by whom the child was injured. Many of the members of the childcare team have represented lots of different parties: parents, children, teachers, nursery teachers, aunts, uncles, friends, brothers, sisters, grandparents, even scout leaders, the whole range of individuals who might become involved in looking after children.
I would say it's imperative that you seek legal advice immediately. You will have the best recollection of the injury and the circumstances of the time. We can take a very detailed statement from you, and we can assist you in securing any evidence that is necessary in support of your position. In most intervener cases, the child has been physically or sexually abused. The work of the court is to identify who done it. Statements will be given, often experts' reports sought, and oral and verbal evidence will be given and examined by the lawyers representing the parents and interveners. This involvement can cause a significant impact on the lives of those within the pool. Social services may become involved with their own children. In the case of a childminder, it's often the case that they are temporarily suspended from caring for children until the investigations in the family court are concluded, which can have financial implications and cause damage to their reputation. Interveners will usually be required to attend court, often giving evidence to enable the court to make a decision as to who has caused the injuries to the child. When something like this happens to a child, the authorities will look to find the person who is responsible and recommend how it should be dealt with. Sometimes the police and social workers will speak to the people concerned, and other times there is a criminal prosecution where someone could end up in prison. In the child protection sphere, the aim is to ensure that that child, or indeed any other child, is not put at risk again, or if there is a risk, those risks can be properly managed. The impact can be lifelong and have far-reaching consequences for your life and career prospects. To have been found to have harmed a child can have significant consequences upon you and impact upon your ability to work with children forever. The police may consider whether to prosecute you. It is imperative to note that when findings are made in children proceedings, they are made on the balance of probability. And that is very different to in the criminal courts, where it is beyond reasonable doubt. I would therefore emphasise that it is fundamental that you seek specialist and focused legal advice as soon as possible. Publicly funded legal aid is available, but it is assessed on a means and merits basis for interveners. Household insurance policies can sometimes provide cover. Insurance might be available through work for nursery and school staff involved in proceedings, and the union may assist if you are a teacher. At Stephensons, we offer a number of fixed fee funding packages. There are a number of options available, and we can discuss your specific needs with you. Here at Stephensons, we have a team of expert accredited specialists who have particular experience in handling childcare cases involving non-accidental injuries and interveners. Please don't hesitate to get in contact with us. We do know that it can be daunting to approach a solicitor in circumstances such as this, but the sooner that you do it, the better, and it enables us to give you the very best opportunity.